Under the Rules of Professional Conduct 3.5, both counsels still have obligations of decorum. Ms. Hardy Cooper has left on at least 2 occasions, and it is absolutely inappropriate if it was a jury trial. That said, Mr. King, yesterday, as we were getting ready to move into a closed argument, you rolled your eyes. I didn't call people out. I'm just going to simply admonish both counsel that I respect better and say I've been warned, and so at this point, should either counsel step over the rules, I'll impose sanctions. Presiding. Thank you. Please be seated. All right, counsel, time-wise, Mr. was at 51 minutes used. Ms. is at 175. Again, it's not exactly equal. Allowing time for closing arguments on Thursday, approximately 300 minutes per day over the next couple of days. If it were divided equally, Ms. would have 238 minutes remaining. Mr. would have 362 minutes remaining. The time from yesterday has already been adjusted for objections. But that's where the time stands, obviously with the caveat that it wasn't absolutely equal as of yesterday. Any other preliminary matters before we get started this morning, counsel?
Yes, I wanted to talk about the issue that we left with yesterday afternoon with respect to whether Mr. could recall Ms. as a witness. We went in.
I believe it's recall and rebuttal,
right.
Both. And so there's 2 different legal standards.
Right.
If he gets ready to recall them, we'll have that argument.
Okay.
As I said, I'm glad that you're prepared. Simply putting a pin in it doesn't allow a person to automatically have that right. Rebuttal is slightly different than recall, but both of them are grounded in law. So if it happens, Ms. Hardy Cooper, I'll take the argument then.
Okay.
Anything further?
So, Your Honor, our intent is to call Mr. as an adverse witness this morning. Out of respect for the time that we have available, my suggestion would be to allow that to happen and then have Mr. King present any direct testimony that Mr. has, and then I can have a cross. We could just handle all of his testimony this morning.
Mr. King, I leave that up to you. If you want cross expanded to the scope of direct, or if you want to call your witness separately, that's entirely up to you.
I probably will want to do the combined, but I'd like to see how far this goes with the direct.
That's fine, as long as you make your decision before cross begins.
Will do.
So a part of the issue that we have, Your Honor, that I was going to try and see if we could get that witness that is scheduled for tomorrow morning to see if she could come in. She could appear today. She can't. She's on a flight until 2 p.m. our time. So she has to testify tomorrow morning. And then Dr. Court is only available in the afternoon. He's traveling back from another court testimony and believes he'll be back by 2 o'clock. He's going to text me when he gets on the road with a better estimate. So I'm just trying to be respectful of that as well, so we can be efficient.
I appreciate all of that. And if Mr. King agrees, then I'll accept that we'll expand the scope of cross to include direct as the statute allows. If he doesn't, then I'm going to let each one of you present your cases in the manner that counsel believes most appropriate. But that may mean that Mr. testifies twice today, just as Ms. did, just in order to get all of the testimony in on time.
Okay.
Any other preliminary matters that counsel would like to address this morning?
No, Your Honor.
Okay. Counsel, you both know that I like just to make sure that everybody knows where we're at on exhibits, that I know which ones I can look at, which ones I can't look at, and to make sure that you all have a clean record. So at the beginning of day 2, what I have for evidence is as follows: 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 21 was not admitted but offered. It remains out. 23 was offered in the entirety. Page 1, without any of the article contents. Page 2 without the article contents but with the attached confidential exhibit. All remaining pages were out, but pages 1 and 2, subject to those caveats, were in. No other exhibits. As for judicial notice taken, where we're at on that, I have judicial notice taken of all orders entered in this case. I have judicial notice of the motion regarding first right of refusal, simply the registry of action material as to the date that it was filed. The registry of action showing that there would be no opposition was the offer of proof from counsel and the resulting order. That's what I have for judicial notice. Anything that I have omitted, anything that we need to clean up before we move into day 2?
You were also going to take judicial notice
Oh.
of the TBO proceedings.
That was, and Mr. King, I do have that and it wasn't written down. The TPO proceedings, there was judicial notice taken yesterday. I can find the timestamp if you need me to. Any objection? Did you have that as well?
I had that as well, but was there a specific pleading from that? Or are they just asking for judicial notice of the entire file?
We asked for the entire judicial notice of the entire file, and Your Honor accepted that.
And I did have that it was the entire file, but I will simply say, I'm still gonna be bound by the rules of judicial notice, so I wouldn't be able to take the allegations in those papers as being true. It's just judicial notice of that action. Yes, the entire action was requested.
So to be clear, can you repeat on the record what the case number of the TBO matters?
I didn't have that in my notes, but I can pull it up for council without
Yeah.
too much
I
delay.
also have it.
I have it.
Go ahead, Madam Clerk.
TPO 24.
Actually, that, we were,
That's not the right one.
that's not the right one. The right one is 2012.
Oh, 2012. I apologize. I do not have that one.
So let me pull it up. Because I don't think we had the case number. Ms. Hardy Cooper indicated that she could get it. I indicated that I could get it.
I have it now if that's helpful.
It would be helpful.
Okay, FV 12.
And Mr. King, should your client wish to double check, we have that on the binder program. It looks like the last documents would have been in 2021. And that was solely regarding a request to seal.
FE 12 dash. Okay, got it.
Yes. That is the only TPO I see from 2012. Anything further? Or is all of that correct from day 1? Thank you for taking the time to clean that up just to make sure that I had everything correct.
It is consistent with my notes.
And Ms. Hardy Cooper, consistent with yours?
Yes.
Okay. Ms. Hardy Cooper, who would you like to call as your next witness? 9:07 a.m. Mr. You take the stand. You were already previously sworn. I believe that there's fresh water and cups up there. If not, let me know and we'll get that sorted. Go ahead.
You're still very focused on the fact that Miss fleeing approximately 15 years ago, is that right?
I don't believe so, no.
It was brought up, you recall yesterday, it was brought up repeatedly in the text messages entered into evidence,
I
correct?
believe it was brought up twice, yes.
You think it was brought up twice in the engine there?
Your Honor, I don't think it's appropriate to laugh at witnesses.
Okay,
Agreed.
I withdraw it. Sorry, I apologize. Okay, will you please open up exhibit, you have that exhibit looking like exhibit 2. Do you have it?
Yes.
Please turn to page 2. And please read your messages on that page.
All of them?
Yes,
Just my messages.
correct.
Come home, I don't want to see you. Next message. Next message. I don't want to be with you anymore. Next message. I'm leaving. Go be with your powerful, important boyfriend. I'm sure He will raise his kids with you since you and him talked about the whole adoption thing. Have a good life. Next message. I hate you. Next message. What? Are you already making plans with him? You whore. You're the biggest piece of shit I know. Get out of my life. I don't want you anymore. Get it? Next message. The only pictures I have are you of being the whore you are. These guys. I don't want it anymore. I'm done and over it. I don't want you anymore. I want you out of my life. You are not my future happiness picture. Next message. He is right. I like the pet name he and his wife gave you, idiot creature. That's what I'm going to start calling you. When you have a little, then you will have a little of him every time we are together. Wouldn't that be nice for you? Next message. Good. I hope you are crying. Next message. You probably are not even upset. Typical, able to brush everything off like it's no big deal. Probably the same way you would him and then come home and pee on a stick to see if you were ovulating to have a baby with me. You're disgusting. You are the worst person I know. Get the out of my life. I hate you as far as I'm concerned. This morning will be the last time you see me. And have a shitty life, you bitch. Next message. That's what I thought. You have nothing to say.
And if you'll flip to the page prior, what day is this message being sent? Are these messages, excuse me?
Looks like it's May 4th of 2010.
Flip to page prior, page 4, please. Do you see on the left-hand side, you are asking her to name him?
Yes,
And you were referring to the person she had the fling with, correct?
yes.
Please turn to page 8, which is also May 4th, 2010. At the top of the page, do you call her a cheating?
Yes.
And then,
Excuse me, I thought the question was about page 8.
That is.
it is page 8.
Okay.
A little bit further down, you see that there's a timestamp for 4:52 p.m. And you say, working late tonight? Wow, working late tonight? Are we still trying to get to the top? That's your message, correct?
Yes, I see it.
Let's skip to page 18 of the same exhibit. You see on the second line, you say, I'm sick to my stomach.
Yes,
Read that message to us, please.
I am sick to my stomach. He is so fucking ugly and you threw everything away with us. I can't believe you. I'm so disgusted with you. You make me sick.
And the next one is don't call me, correct?
Yes,
The date stamp on that is 5/25/2010, correct?
yes,
And that was your anniversary?
I believe so, yes.
You don't recall when your wedding?
I didn't remember our wedding anniversary until I testified to what day it was.
Your next message, you say no, and then you say, I hate you, you suck, you are a piece of shit, you are worthless, correct?
Yes,
And then in the next paragraph after there, you discuss the fling again, right?
yes,
Is that more than 2 times, sir?
yes, but that was all during the time frame.
You
of
said
our affair.
you said earlier that it was discussed 2 times in the text messages yesterday. So
I
You were
meant,
incorrect.
I meant more recently, so I apologize. Back in 2010, yes, I did it a lot.
you also did it after born, correct?
Yes,
And in fact, did it within 3 weeks of him being born, right?
I can't recall.
Please go to page, to exhibit 3. Starting at 9/25/2010, and that's approximately 3 weeks after born, correct?
Yes,
Okay, please say what you, read your message. Read them all.
all of them.
Yes, please.
I said, you need to learn. Next message. I wish you were. I bet your boyfriend would not. Well, I bet you boyfriend would not want to bet with you, let alone run your cards in at 8:30 p.m. I'm sure he has better things to do. Next message. Just think. You could have it better than what you have now. You just have to do everything yourself. I'm sure that Romanian piece of shit does not care for our sports. Maybe you can watch gymnastics with him.
Keep going.
Oh, excuse me. We will see when you get home. All will be told in due time. We will see whose side you are on. Next message. Of course, you care what he likes. If you did not, you would not be such a whore. Next message. Funny how you fought for him. You just proved that. Next message. I hate you.
Okay, so that is some of the testimony regarding the statements you made about the fling, according to my client yesterday, correct? And
Yes.
reflected in your statements here today.
Yes.
Okay, so that, you acknowledge that was some time ago. You also brought it up more recently, correct?
Yes.
And in fact, you brought it up with respect to the right of first refusal that Ms. Requested. Correct?
I don't think that had anything to do with it.
Okay, let's turn to exhibit 13.
Perfect. Okay.
What's the subject line of that message that you sent to her on December 10th, 2022?
Adulterer.
The adulterer was referencing the fling that she had in 2009, correct?
Yes.
So then you weren't really telling the truth when you said you didn't reference the situation in 2022.
I don't think you asked about 2022, but yes, I referenced it in 2022.
Do you recall, do you know when the right of first refusal motion was filed?
I cannot recall.
Okay. What was this message in response to?
That was during the time that I was doing some futsal soccer, and she came to one of his games, and she left before us, left before the game, and I saw her walking a long way away from where we were, and it was snowing, and said, "Mommy doesn't want to know that you got a new car." And I said, "Oh, well."
Objection, that's hearsay. Strike, the motion to strike that answer.
Mr. King?
It's not being offered for the truth of the matter. I think it is appropriate. She asked the question.
She asked a question, and this would not be responsive. As to the hearsay, it is stricken. The rest of the testimony stands. Go ahead, sir.
So I can say he told me that or no?
Without saying what said, since it lends nothing to what's going on when you're sending the message.
Copy that. As we were leaving, Miss was getting into her new car, and she made a little gesture like, "Look what I got," as I was driving by.
So then you thought you should tell her she's an awful human being for belittling me, and I'm glad God gave you cancer?
Yes.
I'll represent to you that the motion to remove the right of first refusal was filed on December 5th. Ms. asked you if you would remove the right of first refusal prior to filing that motion, correct?
Yes.
Okay, and you said no?
Yes.
Then she did file the motion, and included within that motion was a letter from therapist, Ms. Jerry Goddard, regarding that, correct?
I never received a letter from Ms. Jerry Goddard.
Okay. Did you not review the motion that was filed with this court?
I went over it with my attorney, yes, but I didn't see that she wrote a letter.
It was an exhibit to the motion. You're telling me that you looked at the motion with your attorney, but you didn't look at the exhibit?
Objection, I'm not sure what motion she's referring to now. We've got a-
She already, please don't respond,
I'm
but
sorry.
allow me to keep your record clean and rule on the objection. She already titled the question with regard to a motion to remove the first right of refusal. Am I correct? Am I following along, Ms. Hardy?
Yes, Your Honor.
So with that instruction, sir, that's the motion to which she's she's referring. Mr. King, I assume that resolves your objection for
Yeah.
clarity? Go ahead.
Can you repeat the question, please?
You just testified that you went over that motion with your attorney, and then you said you never saw the letter. So the letter was an exhibit to the motion. You're telling me you looked at the motion, but you didn't look at the letter?
I did not read the letter.
Okay. Did you make a call to Ms. Jerry Goddard after reviewing that motion?
Yes.
Did you leave voicemails for Ms. Jerry Goddard
Yes.
after the motion? What was your basis for leaving those voicemails?
That the whole point of going to Miss Jerry Goddard was his not liking going back and forth from house to house with the exchanges. And I let him know that if he was okay with first right of refusal, then that meant if Miss had to do something and go out of town, whether it be a day or 3 weeks, that he could stay with me.
Objection non-responsive.
Mr. King?
I'll submit it, Your Honor.
I agree. The objection is sustained. Would you rephrase the question, please? The answer is stricken.
Yes. What was your issue with Ms. Goddard's position regarding the right of first refusal?
Seeing Miss Goddard because he did not like being switched back and forth from house to house. So
Again, non-responsive.
I let my son know.
Sir, please don't interrupt.
Sorry.
Perhaps it would help if I gave an instruction to counsel any objection.
No.
So when she's asking what prompts the voicemail, what between you and Ms. Goddard prompts the voicemail, we don't need all of the back history as to why you think the child was in counseling. I believe that the sole question put to you is, why do you call Ms. Goddard?
Because I didn't feel like she was on anymore about him being flip-flopped back and forth and to other people's homes. I didn't believe she had his best interest in mind.
So you told me you didn't read the letter, so how do you know what her position was?
At that time, I had not read it.
So you're just reacting from nothing?
I was reacting to possibly time being taken away from me.
Okay. You testified, just to be clear, you testified, you did read the letter that I asked you about. And then you testified that you thought that she was working in conjunction with Ms. to take time away from you. But how would you know that if you hadn't read the letter?
I don't know.
Your Honor, I'd like to play the voicemails that have been previously submitted.
Mr. King?
I'm not sure that an adequate foundation has been laid yet.
If you wish to make an objection, I'll hear it. What would be the missing foundational element for your specific objection on the record?
We have no record in regards to who's speaking, whether it's accurate, all the routine questions for
Wouldn't
foundation.
you need to play that in order for the witness to answer?
He's also already acknowledged that he left them.
He acknowledged that he made a call, and he acknowledged leaving a voicemail. She now wishes to play that voicemail. So she hasn't moved to have it admitted, but I'll hear any objection that you have.
Boy. You know, with a document, you can't ask questions about it until it's been admitted, so it seems odd that the same basis wouldn't exist for this, but.
It's well, to make it offer proof, it's self-authenticating, he says with his name, and it's clear that the two messages are the same voice. And it's been provided for months to the other side.
And so that was going to be my next question. I don't know if Ms. Hardy Cooper actually has to go down this path, given that it would have been provided under 16.2, and I assume that there was no objection as to authenticity filed within the 21 days of production.
No.
Okay. So, again, I turn to you, Mr. King, as to an objection to have it played so that she can ask the question, the witness question about the document before she moves for admission.
You know, well, if the exhibit is not admitted, I will be moving to strike the court considering what was played.
Absolutely. If it isn't admitted, you reserve that right. Any further objections to the record? Okay.
No, Your
What, and I said document, obviously that's not clear enough in the record, my apologies, the voicemail. Can you tell me what exhibit and where it's?
So we have it referenced as exhibit 25 and 26 because there are two voicemails. We have
Which one would you like played?
Let's play number 2 first. I'm sorry, number 26 first, and then number 25.
26 first, and then a pause, please, Madam Clerk.
First, correct?
Please.
Yes, please.
Hi, Jerry. This is calling. I'm being sued because of you, because you listen to me. So please call me back at your earliest convenience, 775. Again, 775. I cannot believe you, as a professional person, would allow to fucking sue me. Call me.
Mr. left that message for Jerry Goddard in response to the right of first refusal issue, correct?
Yes.
I would like to play exhibit 25 now, please.
Hello, Miss Jerry Goddard. I hope you are proud of yourself for allowing somebody like that to manipulate you into you're fucking over a 12-year-old kid. I hope you know that, Jerry. So call me back.
That is also a message that you left for Jerry in response to the right of first refusal issue, correct?
Yes.
Isn't it true, Mr. that you feel like it's disrespectful if someone doesn't respond to you quickly via email? I'm sorry, text message.
No.
You're fine with that?
Yes.
Do you recall in the exhibits presented yesterday, there were several examples of you pushing Ms. to respond to you on your timeline and quickly?
Which exhibit is that?
I'm asking you to recall that yesterday. us talking about that coming up.
That I don't, or that doesn't respond to me in the timely
That you
manner?
push for a fast response from Ms.
What year was that?
You're not answering the question, sir.
Yes, I have asked that.
Exhibit 2, page 2. At the bottom. You already read this, so we don't have to go through the whole thing, sir. But do you see how you said you're probably not even upset, typical, able to brush everything off like it's no big deal. Probably the same way you would and come home and pee on a stick, while, going on. I hate you, and as far as I'm concerned, this morning was the last time you see me off and have a shitty life, you fucking bitch. Right? You see that? At the bottom?
Objection is not a
Yes.
question.
Do you see that?
She's
I
asking
see it,
whether or not
yes.
she sees that section, the objection
Okay.
is overruled.
Is there a response from Ms. before you make your next statement?
No.
And your next statement is, that's what I thought, you have nothing to say.
Yes.
Okay. Page 8, this is May 4th, 2010. Will you read what you said to her and the responses that she had to you at 4:52 p.m.?
Your Honor, it was asked and answered just a few minutes ago.
We didn't talk about this part.
She asked about the first of that series. She did not ask about the entirety of the series. The objection is overruled. Go ahead.
Do you want me to read just mine or?
No, I'd like you to read all of yours from wow to I love you, please answer your phone, and tell me if she responds to any of that along the way.
Wow, working late tonight. Are you still trying to way to the top? All these important people must love that you can't say no to them, and all you want to do is please them. You must be doing everything I think you are doing. Nice.
Are these, you tell me.
Excuse me, next message.
Sorry, sorry, can we stop you for a second? Will you please follow the same format that you did earlier when you tell me the different messages?
Yes, ma'am. Would you like me to start over?
Please.
Wow, working late tonight. Are you still trying to make your way to the top? All those important people must love that you can't say no to them, and all you want to do is please them. Next message. You must be doing everything that I think you are doing. Nice. Next message. Why won't you answer your phone? I want to talk. Next message. I really want to talk. Can you please answer your phone? Are you still at work? Next message. Please, what's going on? Are you okay? Next message. Please call me, please call me, please call me. Next message. I'm starting to freak out. Are you okay? Are you getting these? Please let me know you are okay. Next message. Please come home. Next message. I love you. Next message. I love you. Please answer your phone. Please.
And then what does she say?
I found a safe place to sleep in my car for tonight. I will take my punishment for being such a disgusting. Please do not contact my family. I do not want anyone else involved. I will do this and try to show you how disgusting I know I am. I am trash.
Okay, so on the next page, do you see where, it's 1, 2, 3, the fourth line down of your comments? What do you say next? This is still the same date, correct? May 4th, 2010?
Yes.
Will you read that fourth line of your messages?
Even now you are protecting him. That's the way I see it.
And that, again, you're referring to the person that she had a fling with, correct?
Yes.
Okay. What's your next message?
Why are you still protecting him?
How many exclamation points are there? More than 5?
Yes, sorry.
Next message?
Fuck you for protecting him.
That night, did you ask her to stay in a Walmart parking lot?
I don't believe so, no.
Have you ever asked her to stay, you have asked her to stay in a Walmart parking lot, one that was close to a fire station, correct?
I don't recall.
You've also threatened to burn things in the house, with Miss.
Yes,
You told her that you told her to come home so you can yell at her for an hour?
where is that?
Page 3,
We're still in exhibit 2.
where's Exhibit 2, yes.
Yes,
Okay, so you said to her, actually, I do want you to come home. You had asked her not to come home because you were upset, correct? That day?
yes.
And then you said, actually, I do want you to come
Excuse
home.
me, where was that?
It
I
was
just
the-
misread
It
something.
was the day before. I mean, it was the pages before. You can look at page 1 for reference.
Yeah, I see that.
So you didn't want her to come home because you were upset about the fling. And then you asked her, and then on page 3, when you're continuing to text her, you asked her to come home, correct?
Yes,
And then you say, don't you want to know why? Right? It's the
That-
very next line.
it's above it by about
Okay, so let's just do this.
4 lines, it's above that.
That's okay, why don't you do this? Do you see where you say, ha ha? On the left-hand side, halfway down?
Yes.
Tell me what your messages are, the same way you did before.
Ha ha. Actually, I do want you to come home. Next question. Don't you want to know why? Next message. Question marks. Next message. Are you going to answer?
What does she say in response?
I'm sorry, I was in a meeting with Jacqueline. Yes, I do want to know why.
What did you say?
I said, why don't you answer me? And she says, I did.
What did you say?
I said, so I can yell at you for an hour.
Sir, do you think it's disrespectful for her to ask to make a 30-minute adjustment to a visitation and exchange, correct?
Excuse me?
You think it's disrespectful for Ms. to ask you to change a visitation exchange from 9 to 9:30 so she could get her other child to camp, correct?
At that moment, yes.
And I'll have you turn to exhibit 15. In exhibit 15, your response to her asking for, let me start over. She asked you for a 30-minute adjustment, and then her next message to you is, I've made arrangements, I don't need that, correct? Feel free to look at the exhibit if you'd like to.
Yes?
Okay, so then in response to that, you tell her that this does not work for me, I need to keep this exchange at 9, correct?
Yes?
What's the point of, you didn't need to say that because she'd already resolved the issue, correct?
Yes?
She then tells you, I saw that you read the message earlier today, so that should resolve the timing conflict. And then in response to that, you accuse her of stalking you on OFW, and then bring up the fling again in 2023. Correct?
Yes.
And then you go further, and you send another message about how it doesn't work for you. And you said you're sick of her treating like that you don't matter and that your time doesn't matter, right?
Yes.
For a 30-minute adjustment, correct?
That time, yes.
You tell her to do better.
Yeah.
It's that offensive to you that she's got to do better, and it's disrespectful.
Yes.
Also, you feel like it's so disrespectful and upsets you so much that you bring up the affair of 14 years prior.
Yes.
And accuse her of spitting vinegar in your face by asking for a 30-minute adjustment. That has already been resolved by this time.
Yes.
Finally, you threatened the release of a letter that was written regarding that fling 15 years ago.
Yes.
And you said, I feel the voters should hear about this.
Yes.
In June 2023. Were the school police called on you at elementary school?
No.
In the course of this litigation related to the change of custody motion, you filed some papers that spoke your side of the case, right?
Yes.
Okay. One of those was a declaration that you filed on April 17th, 2024 in response to the judge's order, correct?
Yes.
And in that declaration, you also attached an exhibit that had some of your responses to what Ms. had said about you,
Yes.
correct? Okay. Do you recall what you wrote in that exhibit?
For the most part, yes.
Okay. Do you recall saying, one of the office workers went into the principal's office and said he's here. The principal came out and asked me to wait. During that time, the principal called the school police.
Yes.
Okay.
I didn't know that was on me, though.
You don't recall what you wrote in your exhibit and declaration?
I wrote that.
You learned yesterday that it wouldn't be illegal for you to share information about this case, despite there being seals, with members of the media or other folks. Do you recall that yesterday?
Yeah.
So did you give Mr. Beatles or anyone else, any other media source, information about this case?
No.
You didn't share the sealed document that was published by him?
To Mr. Beatles?
Mm-hmm.
No.
Did any, do you know of any intermediary that would have done such? Someone on your behalf?
There could be several.
And who would that be?
About the information about the letter? Is that what you're asking, is specifically just the letter?
Well, I'm asking first about the seal, the document, the sealed document that was provided to Mr. Beatles that he published. That
I don't know who Mr. Beatles is.
Okay. Did you give anyone from any media-related source that document that we're talking about?
No.
You said that you believe some intermediary may have distributed information on your behalf. So tell me who that is.
Misstates the question, or misstates the answer, I'm sorry.
I don't believe that it does.
She added the words "on his behalf." Makes it a
Would you
different
like to
question.
remove on his behalf?
I mean,
So the question goes back to the original form. Has he given the sealed document, the supplement, to any intermediary. Objection removed?
Yes.
There are a lot of people that have it, yes.
Did you give, the question is, who did you give that document to?
I shared that document after I received it with several people in my fire department because they were my peer support. My brother has it, several friends have it, my cousin has it. I don't know who else they might have shared it with, but this was all back in 2010.
So you're referring to the letter?
Yes.
Okay. The question was actually, who did you distribute the sealed document to?
Nobody.
That was it.
Nobody.
So you wanted this entire case open to the public, correct?
Yes.
And doing so resulted in, if your wishes were upheld by the court, it would result in the media presence that's here today, correct?
Yes.
In doing so, you realize that the allegations of your sexual violence, use of a gun on Ms. physical violence would be reported if the case is open, as you want it.
I didn't know what was going to be said.
Certainly,
I knew everything that would be here would be recorded, yes.
Certainly you knew what was going to be said. It was in Ms. motions and been several filings with this litigation, sir. Isn't that true?
Yes.
This isn't a surprise that we were going to be making allegations of physical violence, sexual violence, psychological violence, release of the letter, everything.
Yes.
Okay. So in wanting the case to be open and knowing, as you said, that this is going to result in immediate coverage, what sort of impact do you think that that has potentially on your son?
Objection, relevancy.
Overruled.
I don't know what impact that would have on him.
Do you think that would make him scared? To know that there's allegations of his dad physically abusing his mom?
Possibly, yes.
Make him anxious about being around you, knowing that there's allegations that you raped her during the pregnancy?
Allegations, yes.
Okay. So then, what's your purpose in opening and wanting this to be open?
I have nothing to hide.
So you don't care about the impact then on.
I do care.
You made no statements in your opposition that showed that you cared about it being private. You realize that, right?
In statements and whatever is in here?
Yeah.
Then I didn't oppose to it, no.
You also had a conversation with Dr. Cord regarding the implications of this case being open, correct?
We talked about the records being sealed.
You didn't talk to Dr. Cord about the courtroom being sealed?
No, it was just about his records, I believe.
So you don't recall him talking to you about the fact that if this is recorded and publicized on the internet, that could harm?
Which is why I changed my mind when Dr. Cord told me that, to seal the records.
You made no efforts in this court to change your mind. I don't see any filing that does such a thing. Did you?
I believe I got a hold of my attorney and let him know that after speaking with Dr. Cord that I was okay with sealing the records. Absolutely.
We're not talking about the records, sir. We're talking about the proceedings being open and potentially put on the internet. You had that conversation with Dr. Cord, correct?
He talked to me about it, about me not wanting the records sealed. And that's,
Okay, so you're denying that he talked to you at all about the fact that the media was intending to come and film these proceedings?
I am not denying the fact about that.
Okay. That's what I'm talking about. I'm not
You-
talking about the, I'm not talking,
He wasn't allowed to finish his answer.
That was the answer. He may have wished to provide more, but that was the answer. She's asking very simple questions about whether or not he recalls the conversation. The objection is overruled.
sir, to be clear, we're not talking about the sealing of the records. There's already a record seal in place. You know, because you read the motion with your attorney and you responded to the motion, that her attempt was to close and make private the full case, and in particular, this hearing right now, because of the allegations that were going to come out. That was fully discussed in that motion, correct?
Yes,
Okay, Dr. Cord, you filed an opposition saying, hey, it should be open, I have nothing to hide, she's a public official, correct?
yes,
Okay, you don't make anything at all in that opposition, correct?
guess not.
Okay, so based on that, there was a conversation with Dr. Cord where he talked to you about the fact that this could harm kids out, right?
Correct.
Okay, and then you told Dr. Cord, I hadn't thought about that, right?
Yes,
Even though it was in the motion that we filed. You didn't think about it, correct?
he gave me a different
That's a yes,
analogy.
that's a yes or no question.
Repeat it then, please.
Okay. You, even though we had filed a motion explaining the impact on, you told Dr. Cord that you hadn't thought about the impact on with the proceeding being open to the public and potentially recorded.
Correct.
Okay. In response to that education from Dr. Cord, you stated that you were going to agree for it to be closed and you would withdraw your opposition, correct?
I was under the assumption it had to do with the records being sealed. That's
So-
my recollection.
So then you still wanted the proceedings to be open? Because again, you're going back to the records, but that's not what I'm asking you about. So despite the fact of his education to you about the impact on being on the internet and being disclosed, you still had the position that it should be open and only the paper should be sealed?
I was under the assumption that the records were going to be sealed, and
You're refusing to answer my question, sir. I need you to answer the
I
question.
don't remember him saying that the cameras were going to be in the courtroom.
You just acknowledged it. Sir, did you want the cameras after you knew the impact on you didn't realize before? Did you say you were going to withdraw your opposition so that the courtroom would be closed and we couldn't have these cameras here?
I don't recall doing that about the cameras, no.
Okay, so you, despite the fact that it's going to be impacted by all of these allegations being publicized, you still wanted it out there.
I guess so.
Let's talk about February 4th.
Okay.
On February 4th, my understanding is that, and you can, and this is what I want to know if it's true or not. My understanding is that in the afternoon at approximately 3 o'clock, you sent a text message to your son that said, "Are you playing your Xbox right now?"
Okay.
Is that true?
Can I see the exhibits?
Would you like something to refresh your recollection?
I can't remember exactly the times, but yes, I contacted him via,
If I show you your
That's
thing
okay.
with it, I'll approach.
And which exhibits, Mr. King can follow along?
This has not been admitted, but we can mark it for identification next in order.
Twenty-seven.
Thank you. Will you take a look at that?
ready?
Is this your text conversation with your on February 4th? Or at least starting on February 4th?
Yes,
Okay. Do you see that text message I was referring to?
Yes,
What time is that?
3:05.
Okay. Did you also attempt to make a phone call or FaceTime call to him?
Yes,
And then the next message is on Sunday, February 4th at 6:01 p.m. Is that right?
yes,
And you saying that, call me, I'm sick of you ignoring me.
yes.
Okay. And then will you look at the rest of the text messages here?
Okay.
Are these accurate text messages for what happened over the next several days?
It looks like it, yes.
Your Honor, I move to admit Exhibit 27.
Mr. King?
Your Honor, this was not disclosed as an exhibit, it's untimely.
Ms. Hardy
Miss-
Cooper?
Yeah, Mr. King made an objection yesterday asking for the best evidence of this conversation when Ms. was on the stand, and that's this.
That is the follow-up of the entirety of the actual conversation at your request, Mr. King.
Well, if she's offering it just to talk about the two messages on February 4th, I don't have to object to that. But it contains more stuff that is beyond my best evidence objection yesterday.
Ms. Hardy Cooper?
Your Honor, the rest of them have been provided in discovery months ago, and they were also included as an exhibit in our trial exhibits that were disclosed at timely.
Okay.
So it's just a continuation of it, it's a more complete exhibit.
So you acknowledge, Mr. King, that the first couple of text messages would go to what you requested be provided yesterday,
It's actually the third and fourth,
the third and fourth?
yes.
Okay, and then the rest of the document, based on your objection of an untimely production, you heard Ms. Hardy Cooper's offer of proof on the record that the rest of it was timely provided. Any further objections?
It was not identified as an exhibit.
I believe it's in the exhibits already, according to Ms. Hardy Cooper.
No, that's not what she said.
It is, it's on exhibit 20, if everyone wants to take a look at it.
Exhibit 20. And I can't look at that. Exhibit 20 I don't have yet admitted, but I'll allow counsel to take a look at it. If you believe I need to look at it in order to make an evidentiary ruling, let me know. Mr. King?
I need a second, you're right.
Ms. Lohman?
The exhibit I'm looking at doesn't contain the two entries that are being referenced, as far as I can tell. These are the ones February 4th at 3:05 and at 6:01. It's all other stuff. Some of it overlaps this new document she's presenting, but I don't see, unless I'm missing it, the ones from 2/4.
I'll review the document in order to make the ruling on the evidence objection. Ms. Hardy Cooper, may I have a copy of whatever has been provided to the witness for the purposes of making a ruling?
Yes.
Oh, thank you. All right, Mr. King, so just that I make sure that everybody is on the same page as me. The document that Ms. Hardy Cooper has marked as Exhibit 27. Everything from the February 5th, 11:09, scared, is everything okay? Through the last page of the document marked as Exhibit 27. Had been previously provided and is fully evidenced in Exhibit 20, correct?
It's slightly different, so it's a little hard to follow. For example, there's a text that's at the top of the page in Exhibit 20, and on this Exhibit 27 is at the bottom. So it takes a couple minutes to go through it, but it seems to contain contacts that are not on February 4th, the dates that we were talking about.
Show me which ones. Tell me which ones.
I think
This is a scrolling and a screenshot, so they're not always lining up the same way, but the text messages are all the same.
what I'm hearing him object to, Your Honor, is not that the rest of that document hasn't been provided. I think he's still going back to the fact that the messages on Sunday, February 4th, were not provided in Exhibit 20, which is what
Right.
you had already ruled on.
And that
That's
was,
what I'm
that
hearing.
was yesterday from the best evidence, but I just wanna make sure, for the record, everything other than, there are 6 messages before the one that I just referenced. That's the only ones that are different from Exhibit 20. So as to Mr. King's objection that they weren't provided, everything was provided except for the 6 messages before Monday, February 5th at 11:09 a.m. Is there an acknowledgement as to that, Mr. King? And if not, direct me to exactly what was not provided. I see it lining up.
Yeah, I only see the 2 as being missing, the 2 on February 4th.
Okay, so you have then everything, then we're only down to the 4 text messages, actually 2.
2.
February 4th at 3:05 and February 4th at 6:01. Correct?
I believe so, Your Honor.
So as to those 2 text messages, Ms. Hardy Cooper is correct. You asked for the complete text messages from February 4th yesterday. And she is providing those. If you want the first 2, the January 22nd redacted, I'll entertain that. But as to an objection, I'm not seeing what the objection is. The 2 text messages in question are being provided at your request yesterday. Everything else as to an objection untimely was timely provided and is evidenced in another exhibit. Are you asking for January 22nd to simply be redacted? Or is there a different objection?
No, I'm only objecting to the portion that has these 2 February 4th messages, because they're not in Exhibit 20.
But your request yesterday was to have them provided at the commencement of today's hearing under the rule of completeness. That is what Ms. Hardy Cooper is indicating. That is why they're being provided.
The testimony that was given was in corroboration of some oral testimony by the other side, not by reference to Exhibit 20.
You asked for the actual best evidence. You asked for the actual text messages. And I apologize, I said the rule of completeness. You asked for the best evidence.
I did.
I will go back and look at the recording, but my notes revealed that there was a request for best evidence. As to February 4th, 2 messages on Sunday. It is the best evidence requested of counsel yesterday. If the document is moved for admission, I'm happy to redact the first 2 messages from January that happened to have been placed on the page. As to the objection that other material was not timely provided, that objection is overruled, having reviewed the documents. The 2 February 4th, there is no dispute that they weren't provided, but they're being provided at the request of counsel. Any further objections that you want rulings on for the record?
No, Your Honor.
All right, Ms. Hardy Cooper, this document is back to you.
So with that, we'll move to admit Exhibit 27, and we will not move to admit Exhibit 20.
The Exhibit 27 moved for admission with the 2 redactions from January 22nd. With the redaction of January 22nd, Mr. King, any further objection?
No.
All right. Madam Clerk, if you'll white out and have counsel initial so that we can confirm that the only 2 text messages that have been removed are accurately reflected from the discussion on the record. Counsel, you'll be asked to initial those after the morning recess. Go ahead.
Thank you. Okay, so going back to that, the first message you sent to him is, are you playing your Xbox right now at 3:05 p.m., correct?
Yes.
Okay, and he doesn't respond to you, right?
Yes.
Okay, 3 hours later, you say, call me, I'm sick of you ignoring me.
Yes,
In your declaration that you filed, oh, sorry, let me go back. Did he call you?
yes.
Okay, and approximately when did he call you?
I can't recall.
Okay. You do recall, though, that you sent a series of messages on OFW to Ms. after that call, correct?
Yes.
Correct. So let's look at the date, let's look at the time so we can get a reference.
Okay.
Okay, it's exhibit 18. Okay, so you'll see that there's three our family was in messages, on February 4th. Did you
Yes.
see that?
Yes.
Is that right? Okay, the first one's at 7:02.
Okay.
And then there's 7:04. Excuse me. And then 7:06 p.m.
Yes.
Okay, so we know that you talked to him at some point between 6:01 and 7:02, right?
Yes.
Okay, so do you recall also making a declaration under oath with respect to your response to Ms. motion, right? The same declaration we were just talking about.
Okay, yeah.
Okay, this is a declaration entered on April 14th. You say under penalty of perjury that you make some statements. And in that declaration, do you recall saying, on February 4th, 2024, Brian attempted to contact me by cell phone and in a period of over 6 hours in length received no response, resulting in some degree of frustration. The language used in any voicemails was regrettable and should not have occurred. Okay, it wasn't 6 hours, right? It's somewhere between 3 and maybe 4 hours, so that's wrong.
Looks like it's 4 hours.
You don't know it's 4 hours, it's somewhere between 3 and 4, isn't it?
I believe the phone calls were after the 6:01.
Mm-hmm. I see that too.
And I believe-
And before 7 o'clock. So
Yes.
3 to 6 is 3 hours, 3 to 7 is 4 hours.
Okay.
Is that right? Somewhere between 3 and 4 hours. And then you say the language used in any voicemail is regrettable and should not have occurred. Do you mean voicemail or do you mean the call? Because we're talking about the call and that item.
I don't understand. I don't know what you're reading.
Okay, would you like to take a look at your declaration to refresh your recollection?
Please.
Okay. Okay, so what I've handed you is your declaration filed, in this case on April 17th, 2024. And I handed you the part that is a specific declaration made under penalty of perjury. What I was reading to you is from item 13. Will you look at that?
Yes.
And did I read it correctly?
Yes.
Okay, so when you're talking about, in this item about February 14th, are you talking about a voicemail or are you talking about your telephone call with Brandon?
I was reading. I'm sorry. Can you repeat that?
Yes. In that paragraph 13, are you talking about a voicemail or are you talking about your phone call?
Okay. It says 6 hours.
Are you talking about your call with, or are you talking about a voicemail is my question?
I don't recall leaving him a voicemail.
So,
I-
is it a phone call then, sir? Can you give me an answer?
I believe I called him twice, yes.
Okay, so you're talking about the phone call.
What are you talking about? I'm sorry, I'm a little confused. Can you please?
It's a simple question. I asked you whether in this declaration you signed under oath in paragraph 13 where you're talking about the incident with Are you talking about the voicemail being whatever you said, inappropriate? Or are you talking about the call? Because it's either a lie or it's a typo.
I understand what you're saying now. Excuse me.
Okay.
I believe it would be line number 5 has not anything to do with what I was talking about. That had to do with the call to Ms. Goddard.
So item 13, line 5, even though it's in the paragraph talking about, you were talking about Ms. Goddard?
I believe so, yes.
I realized that when I gave this to you, I didn't give you the full thing. This is your exhibit that was attached to that declaration.
Okay.
So bear with me, because this one is not paginated. Okay, so when you're having that call with, you raised your voice, didn't you?
I did.
You told him he was being disrespectful.
Yes.
You told him it was rude.
Yes.
It was unacceptable,
Yes.
and there'd be consequences for him ignoring you.
Yes. I don't think I used the word consequences, but yes, I told him that he was going to be punished
He was going to be
or disciplined.
That answers my question. And the call, it made you really mad. You were really mad in that conversation, or him ignoring you.
I was upset, yes.
Let's go back to that exhibit 18 that we were just talking about. So when you were really mad and upset and felt disrespected, you sent 3 messages on Our Family Wizards.
I did.
Okay. So the first one is on exhibit 18, page 1. And it appears that you're retaliating, your response or punishment, retaliation, pick the right word, for him not responding to you for 3 hours was, I'm letting you know that I will no longer support on his cell phone, and I'm not going to pay for half of it. He said you were okay with not responding to me, which is against why I thought he had a cell phone. Thank you.
Yes.
Okay? And that was in response to him not calling you back for 3 hours.
Correct.
Okay? Also in response to him not calling you back for 3 hours, you sent another message 2 minutes later. This is related to a passport renewal, which, if you look at the messages prior to it, you had agreed to the passport renewal and even agreed to meet Ms. at an appointment to do so, correct?
Yes.
Okay, so then you say, I will not be at the appointment for passport since you don't feel to respond to me via cell phone. I can't trust you possessing his passport.
Yes.
Okay. Again, response to a 3-hour delay in his getting back to you. Right?
Yes.
And then the third message, again, 2 minutes later, is about jujitsu and the celebration of life. Isn't it true that you guys were talking about finding somewhere for him to do jujitsu and he was going to try out a couple locations?
Yes.
Okay. And then also, you were made aware that there was a celebration of life for his friend mother who had passed away from cancer, correct?
Yes.
And Mr. was asking if he could attend in support of his friend.
Yes.
Okay. So then you also responded, and this one said, I'm not reading this nor responding to this because of other messages that were passed along to me. I don't trust you, and we can let the lawyers figure this out. And again, this is a response to him not responding for 3 hours. Right?
It was a message I sent, yes, at that time.
It's a response to the incident that happened on February 4th with your son.
Yes.
Tell us what your email address is.
At hotmail.com.
Thank you. You received an email from my office advising you that we were going to be filing an ex parte motion prior to filing it, correct?
I did.
And then you also received an email from us on February 7th, the day that the order was issued, giving you a copy of the order so you know what was in it, right?
I don't recall that, but
Do you review the emails?
I recall, not every day, no.
No, do you review them? You said you review my one message, but you don't review
I
my
don't
messages?
get on my email every day.
Okay, but would you get to it eventually?
Eventually, yes.
Okay. Okay. Well, as you know, the order granting temporary custody to Ms. based on the incident that happened on February 4th, as well as the background information, she was granted temporary sole physical custody, right?
Yes.
Okay, and you're also aware that that order said that you were to have no contact with him until we came in for an expedited hearing so the judge could decide what to do next, right?
I received an email from somebody that I don't know who it is. So, yeah, I guess, yes, I got the email, but I was not served papers until Saturday. So I did not know until Saturday.
So you know when you received the papers? What, you weren't served, sir, with any order from this court, right? You were served with an order from the protection order that was associated with it. Is that what you're talking about?
Yeah, from the
Okay.
sheriff. The sheriff served me
Got it.
papers.
Sure, that makes sense. So there's a personal service for that one, but you also received an order dated February 7th, which was provided to you via email from my office that said exactly what I said. She was granted temporary physical custody based on the February 4th incident, and you were to have no contact with until this court can make a ruling in an expedited hearing.
Okay, I hadn't read it at that time. But yes, I guess I
So
received
you
it,
refused
yes.
to read it when it was sent to you? You ignored it?
I don't even remember when I read that.
Okay.
Yes.
Let's go back to exhibit 27.
I don't have a 27.
It's the one with the text messages.
These, with,
Correct.
yes.
Okay. So we talked about the ones that are Sunday, February 4th. Are you playing your X-Facts right now? That sort of thing, right?
Yes.
And so the order was entered on we provided you a notice prior to it, but the order was entered, on February 7th, correct? I mean, we already established that, right?
Yes.
Okay. So on February 7th, I'll represent to you that we sent you that email at 3:47. And I can provide it to you if you want to refresh your memory on it. But I see that you are sending messages to via text on Wednesday, February 7th at 8:14 p.m., on Thursday, February 8th at 7:17 a.m., Thursday, February 8th at 9:01 p.m., and February 9th at 7:17 a.m.
Yes.
And that's in violation of this court's order that you to have no contact until she has the expedited hearing.
Call to a legal conclusion.
How would questions about whether or not he sent those text messages in violation of the order call for a legal conclusion?
Because he wasn't served yet with the order. I mean, counsel is trying to argue that the email substitutes for that, but.
I'm not asking for a legal conclusion, sir. I'm just asking, did you send those text messages knowing that the order was issued? So I'm going to change the question a little bit. Ms. Hardy-Cooper may go back to the original question. The rephrasing should suffice with the objection, correct, Mr. King?
Yes.
Okay. So when you sent those messages, you knew that there was an order already issued in the case, correct?
No, I had not read the second email that Ms. Hardy-Cooper had sent to me.
So you don't know when you read that email?
I do not recall now.
emails sent by my office. Do you recall?
Again, I remember receiving the one.
And then there's one sent February 8th, 2024. Would you like to see it to refresh your recollection?
Yes?
Please tell me what time that was sent and what was said to you.
The time is at 8:54 a.m.
Time and date, sorry.
February 8th, 2024, 8:54 a.m.
Um, Okay. After the expedited hearing, the court ordered that you could have supervised visitation at the Family Peace Center, correct?
Yes?
Okay. And then you participated in the orientation with the Family Peace Center,
Yes?
filled out an application,
Believe so?
okay? And then they gave you a welcome packet that had the rules in place.
Yes.
At the very first visit that you had with, you violated those rules, didn't you?
Unaware, I believe I did, yes.
And in the welcome packet, is the rule that you violated the one that says that you're not to discuss adult issues, including the case, court, or court documents with the child?
I don't recall having that conversation. No.
So you violated some other rule? You just told us you agreed you violated a rule at your first visit. Is what rule are you talking about?
I don't know because I was told after it happened.
So you've seen the Family Peace Center reports that were filed in your case, correct?
I have not.
You didn't look at the Family Peace Center reports that were filed into your case?
No.
Do you recall we talked about it in the hearing?
This is about the fourth time we had the laughing.
I'll stop.
I understand, but Mr. King, help me understand. I now have a case where a witness asserts that they are not reading materials coming to them. I agree that it's not professional. I also completely understand the frustration. I take a lot of time in crafting orders. I take a lot of time in issuing things and directing people on how to behave. That's my job. The frustration, I'll remind council that it's still a hearing, but I believe some of the frustration may be warranted given the extensive history in this case, including my own admonitions as to my expectations going forward. So to hear on the day of trial that I still have someone who is not reading the file and not taking to heart what's going on in the case is disheartening to me. We're going to take our morning recess now so that we don't have to interrupt the proceedings in 6 minutes. Council, this is the only morning recess we're going to take, so it's going to be approximately 15 minutes. When we come back, we're going to go until noon. Then we're going to take a lunch break between noon and 1:30 today. We'll try to take the afternoon break just for members of the public. I try to take the break in the afternoon sometime around 3:15, but it could be anywhere between 3 and 3:30, depending on where our expert witness may be. We might have to take it earlier today, but a 15-minute recess now. I'll ask everyone to be back in the courtroom, please, by 10:40 a.m. And do we have Exhibit 27? Does the witness have Exhibit 27, or is there another
I
exhibit?
believe the witness has number 27.
Okay, Deputy, can I have Exhibit 27 delivered over to the clerk? Has it already been marked?
I think it's that.
Yes. Okay. The clerk will redact out, thank you very much, the first two messages. When you come back, the deputy will bring to each council. We just mark that those redactions are accurate for the record. All right, I'll see everybody back here at 10:40 a.m.
All right.
Thank you. Go ahead and have a seat. couple of comments as we get started. Go ahead and have a seat, Mr. King. The time will count as mine. Council, the best of cases get under our skin, but I just want an admonishment to everybody of a few things that came up before the break. Under the rules of professional conduct 3.5, both councils still have obligations of decorum. Ms. Hardy Cooper has laughed on at least 2 occasions, and it is absolutely inappropriate. If it was a jury trial, the rights of the defendant to a fair trial would have a much greater impact than if it were a bench trial. That said, Mr. King, yesterday, as we were getting ready to move into a closed argument, you rolled your eyes. I didn't call people out. But at this stage, I'm just going to simply admonish both counsel that I expect better. My ethical obligation is to manage the courtroom, and so you've been warned. And so at this point, should either counsel step over the rules in a violation of 3.5, I'll impose sanctions. Also, a sua sponte order, because what I heard before the break, coupled with what I heard yesterday, does cause me grave concern as to any gamesmanship. We are now an electronic filing jurisdiction. Both counsel are well aware, but I have a case citation if you want it, because I wanted to refresh my recollection before I said it on the record. But in Nevada, notice to an attorney is in legal contemplation notice to his client. I say that again. Notice to an attorney during the case is notice to the client. So I understand you. You're welcome to ask any questions. Yesterday it came up that counsel reported on the record and made an offer of proof that documents in this case that had been served on them had not been provided to the client. It was not that it hadn't been shown to the client, just not provided, but there's an ethical obligation that materials sent to an attorney have been conveyed to the client. Whether that happened or didn't happen, I don't know. But I don't want any gamesmanship with regard to not allegedly having knowledge of my orders simply because they went to counsel and didn't go to a party. So Ms. has complied with the rules requiring her to register as an electronic filer, so she gets instantaneous notice along with Ms. Hardy Cooper. I checked during the break. Mr. King, you have complied with the local rules. You are getting electronic service. Mr. I don't have you. You haven't violated anything. You didn't do anything wrong because you have an attorney. So I'm not saying you did anything wrong. But that period of time that you were representing yourself before Mr. King came into the case, you should have been an electronic filer. We're just not going to take any chances. Mr. King, I give your client until tomorrow at 9 a.m. Actually, that's not going to give him a lot of time because he's going to be in court. I'll give him until Friday at 5 p.m. to become an electronic filer. You can work with our staff. They'll help you set up. The accounts are free. People at the 3rd floor windows can help you set up that account, but you need to register with an email address where you want copies of everything you're filed to go to. But simply understand, sir, you should be monitoring that, but even if you don't, what comes to your attorney, the law presumes you have notice of, even if you choose not to review it. So please, by Friday at 5 p.m., make sure that you become an electronic filer. I just don't want this issue to come up at any other point during the case. And so I say all of that for the record so that we don't have this issue in the future. All right, picking up where we left off, Ms. Hardy Cooper, I believe that you still had questions on direct.
Yes, to your honor, just on that same note, I also pulled a document. And it was Mr. King's notice of withdrawal dated August 28, 2023, where he included the notification that electronic filing is now mandatory for all cases. Obviously, Mr. King doesn't have control of whether his client does that, but it's just another indication that Mr. was informed through counsel.
Okay, so we're going to get that corrected no later than Friday at 5. You have to have that electronic filing account set up.
Right.
Mr. King, anything else for the record?
Yes, Your Honor, just in case we go right up until 5 o'clock, I may ask you to extend it a little bit later that same day.
I gave him until Friday at 5 because we closed trial on Thursday. So that'll give him a full 24 hours, but we're not.
Right, okay.
Yeah, I wanted to make sure that he has plenty of time. So we're finishing trial on Thursday. You have until Friday at 5. It will take no more than a few minutes. And as I said, should you have any problems, we have lots of staff who are here ready and willing to help during the lunch hour if you want to, or before court in the morning. But I make that order sua sponte. I will check the file, counsel, and in this case, I do have to file a motion for order to show cause or a notice of show cause. I will, given the allegations that have come up in court so far. I want to make sure it doesn't happen again. Ms. Hardy Cooper, picking up where we left off.
Thank you, Your Honor. Before we get started, I move to admit exhibits 25 and 26, which were the voicemails that he authenticated and said that were sent, were left on Ms. Goddard's voicemail.
Move for admission of 25 and 26, Mr. King.
I would object on grounds of relevancy.
Do you wish to be heard, Ms. Hardy
I
Cooper?
mean, Your Honor, it goes to the overall aggression that he's shown to all sorts of people and Ms. among others. Also his continued hatred and, plan of domestic violence against Ms.
Mr. King, anything else for your record, sir?
Your Honor, these are two recordings of him leaving a message. Is he angry? Is he swearing? I don't think that this is a basis to modify child custody.
But Mr. King, that's not the standard for relevancy, correct? I mean, in accordance with relevancy, these are just small pieces of an overall case. It doesn't have to be the linchpin of a case or anything else. And it may very well be that I afford it no weight. That's not the issue before the court. Your objection is as to relevancy. So if there's anything specific in that vein that you want for the record, I'll allow you to make it. Otherwise, I'm going to make a ruling.
Nothing further.
All right. As to the objection relevancy, in accordance with the statute, I do find it to be relevant. The objection is overruled. Exhibits 25 and 26, given that that's the only objection, then are admitted. So I have 25, 26, and then 27 came in before the break. Those are the only changes since we started this morning. Go ahead, Ms. Hardy Cooper.
Thank you, Your Honor. I'm going to be referring to the court's record. The court ordered in this case to have Family Peace Center visitation, and then those reports were filed into the record in time. And so I'm going to be referring to those. I didn't ask for them, I didn't put them in my trial exhibits because they're already part of the court's record, but if necessary, we can also add them. So
Are you asking for that?
Yes,
You're from
yes,
Mr. King?
yes.
So if I hear correctly, is it just the order for Family Peace Center? Because that
No,
I have
so-
already taken judicial notice of, or is it the reports?
the reports, Your Honor.
Mr. King, as to the reports from the Family Peace Center, judicial notice?
I'd ask the court to also consider, in the same vein, because they go together, one of our preliminary hearings discussed the very first Peace Center report, and the court discussed the very allegation of violation, and the subsequent reports show no such violation. But I think what happened at that hearing is important to be considered in conjunction with the reports.
So I just want to make sure for the record that I understand you correctly. You have no objection to the Family Peace Center reports, the court taking judicial notice, so long as the court also takes judicial notice of the order following the preliminary hearing immediately after the first set of Family Peace Center visits and the jazz recording where we had that discussion about the alleged violation.
Yes, the recording. I'm not sure that it was incorporated word for word in the order, but yes.
Okay, with that caveat,
No objection.
judicial notice is so taken, it will be not only of the Family Peace Center reports, but the jabs from the hearing. And counsel, I don't have the date of the hearing. I'll try to have that for you during one of the next
I
sessions.
want to
but
say it was April 10th.
It might have been April 10th, it might have been one of the other ones, but I'll state it specifically on the record just in case I get it inaccurate, and then you can correct me, but I'll have that date. But it is judicial notice of the hearing regarding the discussion. So taken, go ahead.
Okay, thank you. So your first Family Peace Center visit was on March 11th, 2024, correct?
Yes.
Are you unsure?
I can't remember the exact dates.
Okay. Would you like to have a copy of the Family Peace Center report to refresh your memory?
No.
Okay. In the Family Peace Center report, it was raised that you spoke to about this case. Do you recall that?
Yes.
Okay. The report said, Dad said he was sorry, he understood. Dad said how disappointed he was with what was happening. Dad talked about the phone calls and Dad mentioned it was not fair that he can't see or talk to you. Is that what happened?
Yes.
Okay. And that is a direct violation of what we just talked about in your welcome plan, discussing adult issues, including case, court documents with the children.
Okay.
Right?
Yes.
Okay, you also said, let's get this back to normal. Dad mentioned he is stressed a lot and he shared that his stomach is in knots and cannot eat at times. Is that accurate?
Yes.
On that visit, you also kissed lips, correct?
Yes.
Also told you at a family peace center visit that he was studying French. Do you recall that?
Not studied, but yes, he talked about
Like learning?
a desire to learn, yes.
Okay, and then you discouraged that desire because you thought the French-speaking population is so small. On your first visit.
Yes.
Okay. On the second visit, you kissed him on the lips again?
No,
Oh, you didn't?
no,
So if it says in the report, then that's not true?
it might be true, I can't remember when I was told not to.
On the third visit, which was April 8th, 2024, you had a visit with him, and on this time, you had asked for a kiss on the lips. And it states around as if he was dodging the kiss. Do you recall that?
No,
Okay, so I will read to you that it says, Dad stood up and hugged. Dad asked for a kiss, around as if he was dodging the kiss. Dad said he wouldn't make him. Is that accurate?
I guess so, but I don't exactly recall that, but
Okay.
yes, if it's in the report.
And then you also, during these visits, said that you can't wait for all of this to be over.
Yes,
And that's also a violation of that rule I just cited to you, correct?
apparently so.
Going back to your declaration you filed and the exhibit associated with it on April 17th, you said, at the bottom, so again, it's not paginated, so it's hard for me to tell, but it's the last page of the exhibit that's attached to your declaration. I am sick of all these accusations I have endured for years since divorcing. She is the main cause of all of my anxiety. Is that accurate?
Yes,
And despite that declaration to you, you have provided 0 exhibits or any corroborating information for that statement, correct?
I believe there is letters from my counselor.
You have
Was there-
presented 0 exhibits in this case. There are
Okay.
0 exhibits that are going to be presented from your side in this hearing, right?
I guess so,
So
yes.
you're not presenting any corroborating information that supports that these things that is done is causing you all this anxiety over all the years.
I guess not.
You have equal access to the family wizard messages that she does. We've gone through many of hers, and you provided none that support your position, correct?
Correct.
Okay. Going back to something that came up earlier, do you recall when I asked you about whether you wanted Miss to stay in a Walmart parking lot? And you said that that didn't happen? Do you recall that?
Yes,
Okay, will you please go back to Exhibit 2? page 10. Excuse me. You there?
Yes,
Okay, so do you see towards the bottom of the page, it says, you have a message, where are you?
Yes,
Her response is a series of X's, and then her next message is inside Walmart buying water, right?
yes,
And isn't this a time when she was going to be sleeping in a Walmart parking lot?
not that I'm aware of, no.
Okay, so look at the next message. It says, okay, don't forget to eat tonight. And then your next message says, you can come home after I leave to get ready for work. See that?
yes,
And then she responds, I thought you were trying to salvage tonight.
yes,
Doesn't that mean that she was supposed to stay away until you had left for work in the morning?
yes,
Okay. Go to the next page. Your first message to her says, I will be checking on you soon. And you're checking on her where she's staying the night, correct?
no,
What do you mean then?
since she's not staying at the house to check in to make sure she's okay.
She had just told you she was at Walmart. Next messages. Maybe you should stay there tomorrow too. That way I can keep an eye on you while I'm at work. Do you see that?
Yes,
And weren't you working at a fire station in South Reno across from Walmart?
I was.
No further questions?